Awesome.
So,
Happy Constitution Week, everyone.
But on behalf of the Vanderbilt Law School Federalist Society, I'd like to welcome all of you. In 1787, when the dust from the Constitutional Convention settled, the framers had drafted a document that would establish an independent judiciary. While most Article III courts are creatures of statute, the Supreme Court is directly vested with judicial power. Throughout American history, the court has played a central role in the interpretation of the Constitution, and today we are excited to be joined by both Professor Blackman and Professor Fitzpatrick to discuss the work of the court this past term. Professor Blackman is the Centennial Chair of Constitutional Law at the South Texas College of Law in Houston. He is also an adjunct scholar at the Cato Institute. His research focuses on constitutional law and the Supreme Court, including writing his best-selling book with Randy Barnett, An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. He graduated from George Mason University School of Law, magna cum laude. Following law school, he clerked for Judge Boggs on the Sixth Circuit and Judge Gibson on the U.S. District Court for the Western District of Pennsylvania. And also joining him is our own Professor Brian Fitzpatrick. Professor Fitzpatrick joined Vanderbilt's law faculty in 2007 and currently serves as the Milton Underwood Chair in Free Enterprise. He graduated first in his class from Harvard Law School and went on to clerk for Judge O'Scanlan on the Ninth Circuit and Justice Scalia on the U.S. Supreme Court. After his clerkships, Professor Fitzpatrick practiced at Sidley Austin and served as special counsel for Supreme Court nominations to U.S. Senator John Cornyn. So thank you both for being here, and we're delighted to hear what you have to say.
Thank you, Dalton. I think I speak for both Professor Blackman and myself when I say thank you to the Federalist Society for putting this event together. And I want to say thank you, Professor Blackman, for coming all the way from Texas to join us. And thank you to all of you for taking time out of your schedule to participate in this discussion. I'm going to interview Professor Blackman for today's format, and I'm going to try to add my 2 cents along the way, but I want the focus to be on our guest that we're lucky to have with us. And I have a number of questions I want to ask you, but I actually want to ask you a question that I didn't tell you I was going to ask.
That's fine.
First, and that is one of my students asked me a very good question the other day. One of my students asked me if I was aware of something like a constitutional law horn book or something like this that would go through the various parts of the Constitution from an originalist perspective. They just wanted to have a little guide, an originalist guide of the Constitution they could study along with whatever they were studying in their con law class. And I thought of your case book with Professor Barnett. I thought of the McConnell, Bode, Paulson case book as well. But I didn't really have anything beyond these case books to recommend. Do you have something?
I do. So the Heritage Guide to the Constitution is a treasure. I'm the senior editor of this book, but not the version that's been published. This is a version that was the idea of Attorney General Ed Meese to have a single volume with an essay in every clause in the Constitution from an originalist perspective. And the best part, it's free.
Wow.
So if you go to heritage.org/constitution, pull it up, whatever clause you want, you go clause by clause. The third edition, which I am editing now, will be published, God willing, in the fall of 2025. We have over 150 authors. It's going to be like 800 pages long. It's a huge effort of work, but something I'm very, very proud of.
Wonderful. Thank you so much for not only alerting our students to that, but alerting me. I can go and get my copy. So we're going to talk about some of the cases from last term. But before we do, I think it is appropriate to discuss some of the ethical controversies that have been swirling around the court. And I should say, I don't have a microphone up here, but if you can't hear me, please let me know and I will speak louder. Sounds like they can hear me okay. So the ethical controversies.
Yes.
You know, so probably the biggest one is Justice Thomas being flown around for some luxury vacations by a friend of his, Harlan Crow, I think the friend's name is. But there was some I'd say smaller controversies. One was Sonia Sotomayor about using Supreme Court staff to help sell her book. And I'm wondering what you think about these controversies. Is this something we should be worried about? Should we do something as a country about these controversies? Is it going to affect the Supreme Court in some way? What do you think?
Sure. So you've seen these stories in the news. I think the first point to make is that the justices themselves, I think, are aware of these criticisms. I think the judiciary as a whole is aware of these criticisms. Indeed, in the last year, rules have been modified to make clear that accepting what was called hospitality, transportation, has to be disclosed. Beforehand, Justice Thomas said the rule wasn't clear. Maybe think he's right, maybe think he's wrong, but now the rule's clear. And in fact, Thomas is disclosing these trips. And in fact, he issued this kind of a, oh, by the way, this sort of this revised disclosure with all these other things that he had taken over the years. People may still not be happy, but I think they're aware. Recently, Justice Kavanaugh said that the court is moving toward what he said was concrete, that's the word he used, concrete proposals to modify ethics on the court. What that probably means is that they're going to be putting out, if not a code of ethics, something that looks like one, to dictate what their policy is. Now, let's be very clear. Whether you're a Supreme Court judge or a lower court judge, whatever the rules of ethics are, discretion will still be involved, right? You've all said the model rules of ethics, you've taken responsibility, professional responsibility. These aren't bright line rules, right? These are standards. And we need to always depend on the people exercising their offices to behave responsibly. Okay? If we think that these justices are corrupt and they have no honesty and integrity, who cares what the rules are, right? If these are just parchment barriers. I believe that the justices are trying in good faith to behave ethically. Now, with Justice Thomas, I think he shouldn't have taken these trips. I said this before. I think it just it doesn't look right. It kind of looks wrong. If I go to Brian's house for dinner and he, makes me some chicken and pizza, whatever, it's fine, right? No one's going to.
But if I make you lobster, too good.
It's funny. If you're in the government, I used to work in the government. There's actually rules on this. If you go to a conference, you can have muffins. Bagels are a maybe, but if there's a bagel with a cream cheese, that becomes breakfast and you can't. And so there actually are fairly, if you're working for the government, there are fairly strict rules about what sorts of meals you can accept. And for whatever reason, muffins were okay, bagels were a gray area, but man, if you have cream cheese in that bagel, you're in trouble. So I wish Thomas hadn't taken them, although it seems that he was in good faith complying with the rules as they existed at the time. But I think going forward, they'll be more careful with disclosures. Let me pull a step back, though. I think this constant reporting on the court's ethics has a sort of mission, and that's to make the court look illegitimate. And for people who only study a very small part of the court, it's working, right? I think the public perception of the court is being influenced by these stories. I think the justices, for better or worse, are taking account of this. And even if the court's decisions aren't in line with this public perception, this perception does, I think, wound the court. And that's why I think they're taking some action. And these are not difficult rules to comply with.
Mm-hmm. So it sounds like to me you support these new disclosure rules. And it sounded like to me you might even support a rule that says they cannot accept something over a certain amount in value. Is that fair
Yeah,
to
I mean,
say?
that's actually the rule now. They can't accept gifts of a certain amount. But the trick was, and this is the wrinkle, accepting hospitality. So let's say your friend gives you a ride to the airport. Do you have to disclose that? No. Okay, well, let's say your friend has a jet instead of a car. You take a ride on his private jet. Is that hospitality? A number of judges over the years have deemed it hospitality. Ginsburg took private jet planes, Breyer took private jet planes, and so on. I think what makes Thomas different is he did it a lot,
Yeah.
and not going to like a conference, but going to vacation in the Pacific on the
Or
yacht.
maybe you'd support then a rule that says you can't accept hospitality over a certain amount.
And that's or at least disclose it if you do.
Yeah.
That's basically the rule now, I think.
The one thing I will say is that I think I agree with you that it doesn't look good for a public servant to be arguably enriching themselves by living a life of luxury that is only being offered because they are this public servant. On the other hand, the justices do make a lot of money from books.
Oh, they do.
They make millions of dollars from their books. And you could argue that's also enriching yourself from your public service position. I will say, though, there is something different to me about going through the hard work, as we both know, of writing a book.
Oh, you think they write their own books? That's cute. That's really funny, Brian.
Fair enough.
Let me make this point. This is actually a good ethical point. The rules actually don't say you can get paid for a book, right? There's a limit on outside income. So if it just teaches a class, they teach these summer classes in Europe, beautiful locations. It's capped at roughly $30,000 to $40,000 a year. It varies a little bit, right? So how are they getting advances for books in the millions of dollars? They get what's called an advance on royalties. And the ethics rules say, and this is actually not entirely clear, if you are entitled to a royalty, you can receive it. So instead of getting a cash payment for a book, like a bonus, they get an advance of royalties. What happens if they never earn the royalties back? That is, they get, let's say, $2 million of royalties, but they only sell $1 million worth of books. You think the book publishing company is going to sue Justice Sotomayor to claw back the extra amount? No. In fact, she'll probably, I'm thinking this, whenever her life ceases and her estate's inherited, they'll just forgive the debt, right? And so I've actually been critical of this. I mean, Justice Barrett got a book deal for short a single opinion for like $2 million. She hasn't done a damn thing, right? They are giving very sizable advances on the idea that if you're a justice and you go to an auditorium, you're going to pack that auditorium and you're going to sell out books. And there's evidence that some of the justice staff are twisting arms saying, oh yeah, order some more books. You haven't ordered enough books. Order some more books for us to sign. So I think actually the book issue is an actual problem. I would simply say royalties are not are subject to the same cap. Look, I wrote a book, you wrote a book. I made a few $1,000s.
30,000.
Yeah, I didn't make it anywhere close. So, if you want to write a book for the good of humanity, go write a book. And if you actually want to earn royalties after the fact, let them pay you the royalties you actually earn, not this massive balloon up front that you may never actually earn back. Anyway, that's just a grievance I have.
You mentioned Justice Barrett,
Yeah.
and I do want to talk about our newest justices to kind of get your thoughts about them. Justice Barrett, I guess, is our penultimate justice.
Not newest anymore.
And so you don't like her book deal, but what do you like about her opinions now that she has written a few? Do you like them? Do you dislike them? She had a very, I thought, scholarly one. She is a former professor. She had a very scholarly one in the Biden v. Nebraska case about the major questions doctrine, which I'd like to talk about. But what's your general thoughts on Justice Barrett?
So Justice Barrett was a professor for her entire career. She was a litigator very briefly after she graduated law school. She also clerked for the Justice Scalia, the same person that Professor Fitzpatrick clerked for. And she's still a professor. If you read her opinions, she's professorial. I feel like when I read her opinions, it's a lecture. Like she's explaining it in what this almost Socratic dialogue, very clear, very easy to understand. And one thing about Barrett, she wants a theory, right? If you come to court, ask for some remedy, ask for some new relief, unless you've thought things through, you're going to lose, right? She wants you to understand, what are the implications of your theory? Where is this headed? I'm not going to just give you a free one-off and clean up later. I am not going to connect the dots for you, Justice Barrett says. In at least 2 cases this term, she actually chewed out counsel saying, you've not given me a theory. I don't know what to do with this. You've not told me. You're giving me point A and point X, right? What happens between A and X? How do you connect those dots? And so
when you say a theory, she wants some coherent way to draw a line between the cases that qualify and the cases that don't. So it's like being in class where we ask the students, how do you distinguish this from that?
Right. And so there was a case, this term called Burkeen, which involved the Indian Child Welfare Act, a very complicated case. But the lawyers were basically arguing that this big statute was unconstitutional. And this is a statute that affects a lot of aspects of tribal life. And what she was saying is, look, you need to tell me how your theory affects all these other aspects of tribal life. And if you can't do that, I'm not ruling in your favor. And she didn't. She ruled with the majority. There was another case called Fulton from a couple of years ago where the plaintiff said, we want to overrule Employment Division versus Smith, a very famous Scalia opinion on free exercise. And Barrett said, wait a minute, hold your horses, right? Slow down, pump the brakes. Here are all these questions I have. If we overrule Smith, all these other questions will rise. You need to answer my questions. Now, of course, all those questions are answerable very easily, right? They're an amicus briefs nonstop. She just didn't like the answer to those questions. But at least she says, I want you to answer my questions. And I think that's just sort of the aspect of Barrett that when you're litigating, you need to be ready for those questions. And she may not like your answers, but at least you have to at least have something that you can put up forward.
Well, what do you think about what she did in this student loan case? Biden v.
Yeah,
Nebraska.
Nebraska. Mhm.
So she joined the majority there.
Yes.
She said that all these poor students can't get their loans
Sorry.
forgiven. And she did it in part based on this major questions document.
Yeah.
So what do you think about what the majority did there? What do you think about what Justice Barrett said there?
Okay. How many of you followed this case, student loan case? Okay, enough hands. Also,
I'm
describe
surprised
it.
not all of you.
I'll describe it
This
very
is
briefly.
money in your pocket.
There's a statute called the HEROES Act passed in the wake of 9/11. And the statute gives the secretary the power to waive or modify certain provisions of student loan law
It
in the
actually
event of
says
an emergency.
waive or modify any provision,
Yeah.
I think it says.
Yes, sir.
Yeah.
Provisions of student loan, the student loan regime, which is administered by the Education Department. During the COVID pandemic, the Trump administration said, we are going to waive or modify, and what that means is we're going to suspend payments and suspend interest and suspend penalties. If you don't make your payments and loans during COVID, we're going to just look the other way. No one really complained too loud about that, as I recall. A lot of stuff was going on, right? But then fast forward to the administration.
Because everybody was getting some money from the federal government.
Oh
during
man, the
this time.
graft was running.
PPP.
I didn't get a damn penny. I got nothing. I just sat by my computer talking to students on Zoom all day. That's all I remember. But then fast forward to the Biden administration. They said, okay, Trump, you waive penalties, hold my beer. And they decided to enact this massive forgiveness policy that would have just was hundreds of billions. I can't remember the exact amount.
Yeah, it was 400 billion.
I think that was the number. Yeah, 400 billion. I mean, this is a big amount of money to say, okay, never mind. We're going to just forgive this debt. Now, Congress had considered these bills to suspend debt, and they didn't pass it. Okay, but the administration said we're going to do it on our own. We're going to go forward with this. The big challenge here was actually standing, and I don't think that's what Brian wants me to talk about. But the court found that the state of Missouri has standing because of this group called MOHELA. It's a higher education loan authority, and they would lose some fees if this policy went into effect. So that was an injury, and the state could sue on behalf of MOHELA. That's not important.
Let me just ask you this before we move on to the merits. Do you agree with me that the standing argument that the majority accepted was weak?
Very.
Very
I don't
weak.
think Roberts was right, but Roberts and I have a love-hate relationship. When he's on fire, he's the best. No one can touch him. When he's making stuff up, he's the worst. Right? Like when Roberts is in dissent.
I hope he doesn't watch your YouTube channel.
Oh no, I'm actually blocked in his chambers. It's actually a filter. And that's Kavanaugh's chambers. But no, but I mean, when Roberts is in dissent, cherish it because he believes what he's writing. Right? When he's in dissent, he believes it. When he has a 5-member majority, whatever goes. He's still a lawyer. He's always an advocate. Anyway, but the standing analysis was sort of weak. The idea was, well, MOHELA would collect some fees if people, service their loans, and by eliminating the loans, there are fewer fees to collect. But of course, MOHELA wanted this. Who would they rather collect from, the feds or from a bunch of deadbeat students, right? I mean, it's not easy collecting money from students who don't have money, right? That's not a good business model. So MOHELA wanted this Biden policy. It was sort of backwards.
And they did not support the challenge.
They were silent. They didn't support it. They didn't oppose it. The lawsuit was brought by the Missouri Attorney General. And there was a question under Missouri law, can the AG bring suit on behalf of MOHELA? I have no idea what the answer is. I really don't know. Neither did John Roberts, but he said yes. Yeah. And this is one where, the standing kind of just, they got to the remedy. The remedy, I think, was probably right. Again, the statute uses the phrase waive or modify any provision of the education law. And the court invoked what's become fashionable as the major question doctrine, the MQD, if you want to be cool, right? What's the major question doctrine? Well, Scalia described it this way. He said, well, when Congress passes a statute, they don't hide elephants in mouse holes. If Congress wants something really big, they're going to tell you. And if the George Bush era Congress really wanted to spend $500 billion in loans, they would have said so directly. And the Chief Justice said this goes beyond the scope of the statute, and we would expect a clear statement from Congress. But then wait a minute, aren't we textualists here? Justice Kagan says in dissent, why are we looking at what Congress didn't do to interpret a statute? Who cares if Congress didn't enact a student loan bill? We have to look at the text of the statute and waive or modify any, seems pretty broad language. And then here comes Justice Barrett, who wrote this concurrence that no one else joined, because I don't think anyone else agrees with it, but it was very professorial, right? And Justice Barrett said, well, the major question doctrine, it's not about trying to avoid delegation problems. It's not a substantive count. It's just about context, right? And so reading statutes in context. I don't know. I think she's trying to persuade herself this is a thing. And she did the best she could. And I think, frankly, it's the most thorough defense we've seen of the major question doctrine. Gorsuch had an opinion the prior year in the West Virginia versus EPA case, which I'm actually more partial to because I view as a separation of powers doctrine, but at least Barrett's trying. So on our present court, there are 5 or 6 votes for the major question doctrine, depending how you count. The lower courts are now, I think, struggling with this to say, what do we do with this, right? Because really anything can be framed as a major question, right? How big is big, right? Is this an elephant in a mouse hole? Is it a woolly mammoth in a mouse hole? Like, what are we talking about here? So I don't know how far this goes, but all I know is that Justice Kagan is not happy. She keeps dissenting very vigorously on this point. And Robert's like, yeah, whatever. I got the votes. And then Barrett's at least trying to do something, which I appreciate. And Kagan actually said Barrett made some good points. I think there's actually some Kagan smooth. Oh, she's good. She's trying to draw Barrett to the dark side.
She's better than smooth. I think she is the best textualist on the United States Supreme Court. I think Elena Kagan is a smart and sophisticated textualist. I really do. I think she is so strong. I think she was right in this case on the merits. I think the word waive any provision the secretary deems necessary is very broad. And I just do not think this major questions doctrine can resuscitate the majority, because the doctrine is an invitation for judges to start to imagine too many hypothetical people out there. What would these hypothetical people think about this or about that? How major is the question? It's really a recipe for too much judicial discretion, I think. And it reminds me of this canon against absurd readings, which Justice Scalia also endorsed. And I think it was a big mistake, because if the literal words mean something, you should follow the literal words, not ask, is it so absurd that some person would think that no one really meant what the literal words said? I think that's just too much discretion, because you just open up a Pandora's box. And I will say, by the way, one of the examples that Justice Barrett gives in her concurring opinion to support the major questions
children
doctrine
and the babysitter?
is the babysitter.
Oh, goodness. Okay.
I don't know if you've all read this
I wrote
concurring
about this.
opinion yet, but she says, listen, if parents leave their kids with a babysitter and they give the babysitter a credit card, I guess they leave for the weekend, and if they give the babysitter a credit card and say, they make sure the kids have fun, Justice Barrett says a reasonable observer, a reasonable person, a reasonable babysitter would understand that to mean you can use the credit card to buy some pizza and then entertain the kids at home. No one would understand that to mean you can take the kids away for the weekend, spend the night at an amusement park, use my credit card for a hotel at the amusement park. No one would understand that. So what some professors did is an empirical study.
Okay, and I respond to this one, but go ahead.
They use this like MTurk type thing, where you can take surveys and earn a little bit of money. And they asked the babysitter question, and most people thought it was a reasonable interpretation of the instruction to go to the amusement park overnight.
How many of you have kids? Okay, so just people have kids. Would you understand it to be reasonable?
Well, we only have one data point.
And that was my point.
I would lose my mind.
Right. So actually, I wrote a post called "Major Question or Lax Parents," and the point was, people who take $1 from MTurk probably don't have kids. If they did, they'd be doing something else with their time. So it is contextual, right? What one person thinks is good parenting, I think is horrible babysitting. I would fire the babysitter. I asked my dad. He said he would have called the police and had filed a missing person report if he found a babysitter did that. Like, I actually was writing this post, my dad sitting next to me. So anyway.
But I guess my point here is, do we want Supreme Court justices engaging in these thought exercises, or they just want them following the words?
Yeah.
That's where I guess I come out on
Yeah.
this. Anyway, okay, let's leave that one alone. Maybe the students will have something to say in the Q&A.
When you have children, you can then pay for your student loans. It'll all come together, I promise. It'll all make sense.
What about our newest justice, Ketanji Brown Jackson? What do you think about her work so far?
So I went to her confirmation hearing. I was in DC just by chance. I was able to get some tickets from a senator, and I thought she did actually pretty well for a confirmation hearing. I thought she was cogent. I thought her answers were sharp. There were some, sort of stupid, unfair attacks. Like one was, they were really hitting her hard on some of her criminal sentences. That she was too lax, to use the word again, on some. I think there were child pornography cases, and I'll just say, and I clerked in the trial court. The sentences for child pornography are so out of whack. And you may think, oh, Josh, you hate, I have kids, right? Just the number of years you have are so staggering. And the way it works is every picture you have is like another point towards sentence. So, when you had magazines and Polaroids in a shoebox, that maybe makes sense, right? But when you have, a hard drive with a terabyte of photographs, it's just so easy to amp up the number of photographs you have. So I thought her hearing went pretty well. She's been really active on the bench, and there are numbers in this. She's asked more questions than any junior justice in modern times. And so, you would say she hit the ground running. And she's articulating perspectives that may not otherwise get articulated. In the student loan case, in the affirmative action case, she's articulating some of the originalist perspectives on race-conscious measures. So I think she's actually done pretty well. And I wrote this in a blog post this year. What was it? Coinbase versus Bilski? I want to get the name. Okay, so I thought her best opinion this year is one that none of you actually read. It was a class action case. Brian, did you read this one?
Isn't it about arbitration?
Yeah.
Yeah.
And I think she wrote the dissent. Seriously, totally boring case. Coinbase versus it's a Bitcoin case. BIELSKI. It's about interlocutory appeals while arbitrary is ongoing. I mean, look, this is stuff that will put you to sleep. She ran circles around Brett Kavanaugh. I was like, Kavanaugh wrote an opinion for majority that was like 10 pages long. Do you ever see a Supreme Court opinion that's 10 pages long when it's a 5-4 decision? This opinion was so good, Thomas joined the Jackson dissent with Sotomayor and Kagan. So again, I'm just giving you a case that's not ideological, that no one would even care about. But I thought her analysis was really strong. Kavanaugh didn't even respond to her in any meaningful sense. I thought that was kind of like, I don't ask my Kavanaugh, just don't. My blood pressure goes up too high. But so anyway, so I think she's doing very well. I think her opinions are strong. I don't agree with probably a lot of the dissent she writes, which is fine. But, on a non-ideological case, she was sharp. And I think she got the better of the argument, and she persuaded Clarence Thomas, who joined not all of her dissent, but most of it, which is, that's a pretty good marker that Thomas is also can be persuaded by a good idea. It's not just ideological for him.
So I have to read that opinion. I have not read it yet. And so I'm happy you directed me to it, and I will read it. I really only know of her work in the affirmative action decision. And so I do want to talk a little bit about that. And I will tell you, honestly, I was disappointed in her dissent.
Okay.
Because I thought it was completely irrelevant. The dissent is all about the very sad history of discrimination against African Americans and the lingering effects thereof. It was not about the educational benefits of diversity. And that is what that case was about. And so I just felt like she was, using some very emotional rhetoric that was really irrelevant to the legal issue in the case. Am I being unfair there?
Yeah, no, I think that's right. And I was sort of hoping that Jackson would have written an originalist dissent on the 14th Amendment, talking about, the Freedmen's Bureau Act, another legislation that was race conscious.
But again, that doesn't go anything to the educational benefits of diversity.
No,
I'm
she
willing
didn't
to
touch that.
grant
Okay.
that as original understanding,
Yes.
some race-conscious measures were
Right.
appropriate and constitutional to overcome the discrimination that the slaves
Yeah.
just faced. I'm willing to grant that.
She was addressing racial discrimination writ large.
Yeah.
Like it was like a societal approach of all the facets of racial discrimination. And if you read the Thomas dissent,
I think he's guilty of the same thing.
and in some regards, they both accuse each other of doing the things that they themselves do, right? They both accuse each other of going beyond the scope of the question when they both sort of go beyond the scope of the question. And they're addressing sort of broader grievances concerning race as a whole. Yeah, I would have liked to have seen Jackson, as Professor Fitzpatrick said, actually drill down to defending Grutter, defending the idea that there are certain pedagogical benefits from diversity, but she went 180 degrees in the sort of opposite direction.
I feel like no one really defended
No one did.
the
Only
pedagogical benefits of diversity as a
Yeah.
compelling interest. And I
Yeah.
think it's very hard to defend, to be honest with you. And I think it's hard to defend because no one knows how many people of each race you need around to get these benefits. No one is willing to say, we need X number of African Americans, we need X number of Latinos, we need X number of Asian Americans. No one's willing to say those things. And then, a lot of times the numbers that they have in their universities are different for each race. And so a question then arises, well, why do you need a different number of each race to get the educational benefits? There's no answer to these questions.
Yeah.
And so I think it's a very weak justification. I'm happy the Supreme Court didn't quite say you can never use that justification, didn't quite overrule Grutter, but they pretty much said you can't do this anymore, even if we're not going to overrule Grutter. Don't you think? I mean, Grutter was basically overruled.
Yeah, I mean, at this point, the idea that you need affirmative action because you have certain benefits of having different races in the classroom, that's gone.
You think that is gone?
I don't think a university can assert that anymore.
Okay.
I think they can only assert at the front end, saying that when we're admitting people, we want to have people who have overcome adversity, and one of those ways they can do this is because of race. I think it's a front end thing versus a back end thing. And to be candid, I taught Grutter for a decade in con law. It tokenizes people. It's like, okay, you're here because you can say things we find useful. Go ahead, say things they find. I mean, who the hell are you to say that, right? In other words, you're a student just like anyone else. Why is it your job to tell people what some other perspective is? That's not your job to be here as a student. I mean, so the Grutter rationale, which came from Justice Powell, not exactly the most enlightened thinker on race, always had deficiencies. And I think Justice Jackson basically just cut it loose. Yeah. And she reverted back to Justice Thurgood Marshall's dissent in the Bakke case, saying that after 400 years of oppression, a little bit of makeup helps, but that doesn't affect all racial groups equally. It doesn't affect all demographic groups equally. The entire list of acronyms, every group you can think of, that doesn't fit. She wrote from the perspective of Black Americans, and I think she was basically articulating what Justice Marshall articulated. And then you have Justice Thomas saying, well, I am articulating the Thurgood Marshall position in Brown. It's like, no, that's not Brown. And then you're finding what Brown means. So they're just 180 degrees out of phase.
And I think I think it will be more fruitful if the future litigation in this area is all about the past, overcoming past discrimination and that rationale. I think that's a much more fruitful place to go. And I think it's actually going to be a difficult question for originalists, whether the Equal Protection Clause allows race-conscious measures to remedy past discrimination. Because, there were programs right after the 14th Amendment was ratified that seemed to be pretty race conscious. Have you looked into any of this stuff?
Yeah, no, I've looked into it.
Is that in your heritage book?
Yeah, it's in there.
Okay.
Yeah. I mean, the response from the lawyers for the students is, number one, this was not race conscious, it was based on the status of slavery. I say, well, Josh, of course, that's stupid. All the people who were slaves were people who were Black, right? So you may not like that first argument. The second argument is, okay, maybe those were proportional measures in 1868, but those become less proportional in 2023, 150 years later. So their response to that, but you can't ignore these sort of programs that were enacted in the 1860s.
I thought a very good question at the oral argument that I think Justice Kavanaugh asked was, what if the preferences were only for people who could show they were descended from slaves in the United States of America? And I think that's a harder question to answer as an original.
I thought he was going to concur on those grounds. But I mean, just think about it. That would exclude Hispanics. That would exclude Native Americans. That would exclude gays, lesbians. It would exclude almost all other beneficiaries of various affirmative action policies and would limit to just one discrete set of people. So someone who immigrated from Nigeria in the 1960s would get no consideration at all, versus someone who perhaps descended from, from the 1860s, right? So you have to almost a genealogical survey, stapled onto your college application, and I think that's why Kavanaugh didn't go down that road, but he asked about it very clearly.
Okay, well, we can probably talk more about this case in the Q&A if the students
Yeah.
want to.
Yeah.
But I think we should move on.
Yeah.
And just let me ask you, what are some other cases from the term
Yeah.
that you thought were worth talking about with our students?
Oh, let's talk about personal jurisdiction. I love this case. Are you teaching Civ Pro this semester?
No, but we actually had the lawyer. So you were talking about
Okay,
Mallory.
yep, yeah,
The
actually-
Mallory v. Norfolk Southern case.
Yeah.
We actually had the lawyer who argued for Mallory, Ashley Keller,
Smart guy.
here to the law school, and we did a moot court for him and with all the students, and it was a lot of fun.
Did any of you attend that? All right, good. So let me talk about this case. I love this case because it's not ideological. In fact, the lineup in this case, let me just make sure I get this one right. The lineup in this case you'll never ever see again. All right, so majority opinion, Gorsuch, Thomas, Alito, Sotomayor, Jackson. One more time. Majority. I get that right? All right, I think I got it. Gorsuch, Thomas, Alito, Sotomayor, Jackson. Okay, dissenting. Barrett, Roberts, Kagan, Kavanaugh. You will never again in your life see that split. It will never happen. And then why? Because Barrett taught Civ Pro. Kagan taught Civ Pro. They like international shoe. They like minimum context. They like the stuff they would taught for a decade. And you know what? Gorsuch says, burn everything down. That's the Gorsuch approach to the world. Burn everything down. Like Sherman marching to the sea, right? Whatever's in the path, got to go. This is a case about personal jurisdiction. As you probably recall, usually if a court has personal jurisdiction, if a business is incorporated there, or there's some minimum context, which is the test for international shoe. The minimum context test isn't really an originalist test. They were sort of just made up in the 40s, just kind of made up to make commerce work better. Okay.
Back in that golden age of making up constitutions.
We don't do that anymore. We stopped doing that a long time ago, right? And so Pennsylvania has this weird statute.
I think we've toned it down a bit.
So now we have these major questions. This is different.
That's textual stuff, not constitutional stuff.
So Pennsylvania has this weird law that says if you do business in our state, you must consent to personal jurisdiction. So you have a railroad, Norfolk Southern, which has tracks all over the country, and they do business in Pennsylvania. So they consented to jurisdiction by the statute. A tort happens. I'm going to simplify it to make it easier. So a tort happens in Virginia. The plaintiff is a Virginia citizen. The corporation is a Virginia citizen. So where's the lawsuit filed? Philadelphia, of course, right? And then, so of course, the railroad says, no, there's no personal jurisdiction. There's no contact between this injury, this tort, and what happened in Virginia, right? And there's just no context. But Pennsylvania says, wait, we have this statute. And they tried to invoke it. So Ashley Keller, who's a very, very smart lawyer, I think this is his first SCOTUS argument ever,
Yes.
and he won a remarkable 5-4 decision. He actually came to my class over Zoom to talk about it. And he argued that, wait a minute, right? The due process clause says nothing at all about this. The Pennsylvania statute is fine. And by a 5-4 vote, the court narrowly agreed. And I'm saying narrowly because the 5 votes was very fragile. There was a precedent called, something Pennsylvania Fire?
Mm-hmm.
Pennsylvania Fire Insurance in 1917, which said that this sort of statute is valid. And Alito said, okay, you know what? I'm going to stand by this precedent, and I'll give you a 5th vote. So Keller won, but Alito did not accept all the rationales of trying to reimagine the due process clause. You got Barrett writing a professorial dissent saying, what are you doing? International shoe overruled all these old precedents. You can't have anything consistent with international shoe, but she was in dissent, and she was very upset. Kagan also is probably very upset by this, because again, they've
There
taught.
is a line, is there not, Professor Blackman? There is a line, I think it's the Schaefer case, if I remember from my teaching Civ Pro days. Now, the Schaefer case, this is the Delaware statute about if you own stock in a Delaware company, someone else probably remembers the facts. but
Someone
I'm
say
not-
in rem. I heard in rem.
Yeah, quasi in
Oy
rem.
vey, you're giving me
But-
PTSD.
But there's a line in there. Isn't there a line in there where they say all the precedents contrary to international shoe are hereby overruled? It's a footnote, okay. That's,
I think what the court basically said was that's not enough.
yeah.
And
Be
I think
specific.
I think-
Pennsylvania Fire is overruled.
I
You gotta
think-
say it that way.
yeah, I think you have to. I mean, the problem is international shoe, for better or worse, was a revolution. It changed the way personal jurisdiction worked, and the court didn't clear all the underbrush. And it took to 2023 for this other statute to come up. So, for example, you had the tag jurisdiction, otherwise, right? So you have some stuff that's not. Remember the airplane, right? you're allowed to do this. But this is potentially a big case also on dormant commerce clause grounds, because Alito said, wait a minute, why is Pennsylvania putting such a burden on commerce? I mean, just imagine for a second that California enacts a statute. Any business that does any commerce in California subjects to personal jurisdiction. So you have a tort that could happen, in Alaska, and we're going to sue you in California because you do business there. That the Chamber of Commerce has nightmares about this case, right? This all shows the court's conservatives are not always pro-business. Gorsuch, Thomas, Alito, this is probably one of those anti-business decisions in a very long time I can think of from the Roberts Court. Roberts and Kavanaugh, they were with the proceduralists. So, okay, this is too much. Let's go back to what we know. We know about the shoe case. We don't know that. By the way, International Shoe Factory in St. Louis is now a children's museum. So if you ever go to St. Louis, it's a children's museum. You go visit it. They have slides and everything. It's kind of cool.
So, I have a little blog post about this case on the Federalist Society website, so you can read my thoughts in more detail there. But I was disappointed in how this case unfolded because it really had a lot of potential to effect an originalist revolution in personal jurisdiction law.
Yeah.
Because the reality is the originalist understanding, I think, of personal jurisdiction is Pennoyer v. Neff, which you all remember. That's got all the rules of originalism, because that was decided around the time that the 14th Amendment was ratified. And so those are the rules that I think originalists should want to adopt. And there was potential here to say, you know what, we're going to overrule international shoe and go back to that era where if a state says, if you want to drive a car in our state, then you have to consent to jurisdiction. If you want to do business in our state, you got to consent to jurisdiction. I mean, those would be the old rules. And I thought they might bring them back because we have all these originalists up there now, but they didn't want to pull the trigger on that. There's a lot of consequences that would unfold if that happened. And I think a lot of them are very uncertain about those consequences.
And look, I mean, Kagan as a liberal, you think she might want that, but she's a Civ Pro professor. She's dyed in the wool. She will not go back on international shoe. That is her minimum contact. That's her lodestar. Yeah. But go listen to the argument in that case. That was just a fun case. You could tell that they were like thinking back to Civ Pro's one. It was kind of cool.
I think it's going to be probably a very short-lived victory for the Ashley Kellers of the world because of Alito's concurring opinion. He says this needs to be reconsidered on the Dormant Commerce Clause point, because maybe this law that Pennsylvania has is a violation of Dormant Commerce Clause. And so and he kind of intimated in his opinion how he thought the Dormant Commerce Clause analysis should come out, and it wasn't very favorable to the Pennsylvania law. So I suspect we're going to see one of these cases come back, and they're going to rule 5-4 the other way. The Dormant Commerce Clause says Pennsylvania's of the world can't do this.
And international shoe survives. The soul exists. Get it? Soul.
Okay, let's do one. Let's do one more. I'm going to ask you for one more case from the term, and then we can open it up for the students to ask any questions.
All right, let me give one that's not 5-4. I'll give you a 901. I like those. So this is called Groff versus DeJoy. Involves a person who worked for the Postal Service. He is a evangelical Christian who did not work on a Sunday. So I think, oh, great job, work for the Postal Service. They don't do business on a Sunday, right? Okay, Amazon, right? So you may not know this, but all those packages show up on your doorstep on Sunday. A lot of them are delivered by the Postal Service. And so he originally said, I don't want to work on Sundays. And it became very difficult to accommodate him, right? Because think about it. If you don't work on Sunday, someone else has to. So you're either paying overtime or you're giving someone an undesirable shift. And this guy never actually has to work on Sundays. For decades, the law seemed to be that if a religious accommodation imposed even a de minimis burden on the employer, they did not have to grant it. This was a case called TWA versus Hardison from 1978, maybe plus or minus a couple of years, right? Hardison said if there's a de minimis burden on the employer, then you don't have to grant a religious accommodation. That was the law for decades, and lots of religious liberty litigants said this is terrible, right? Any other accommodation has to be reasonable. Install a wheelchair ramp. Well, that's pretty darn expensive, right? But you have to do it, right? Other types of accommodations you have to do, but not religious. So the Supreme Court did not overrule Hardison. They simply said, You guys have been reading it wrong for 50 years. Here's how you really read it. This is Robert's class. It's actually a Alito opinion, but this is his idea, right? Where the court said, okay, we're going to just reinterpret a half-century old precedent, which you've been reading wrong all this time. All of you really smart. Even Judge Easterbrook had an opinion, which apparently Easterbrook's wrong. He's not usually wrong. You're all wrong. You're all screwed up, right? And so more or less now the rule is you have to accommodate religion unless there's some sort of exceedingly large cost involved, right? So this is a very, I think, a good ruling for religious freedom. It was not 5-4, it was 9-0. I think that's a good thing to have. We'll see if the lower courts sort of follow suit. But, I just feel stupid because I've been reading this case for years and I was just wrong, right? I just read the case wrong because, they're smarter than us.
So is it fair to say you're a pretty big religious liberty fan? I mean, you made some comments earlier about Employment Division v. Smith, which made me think that you think that case should be overruled.
I am mixed on Smith. I don't know that Smith was right. I also know that Sherbert was right, the predecessor case. So I'm very mixed, but I do a lot of religious liberty litigation that I care about. But this was a case that wasn't hard. I mean, this is not just about Christians, about Seventh-day Adventists, people who wear hijabs, who wear different types of head covering. This is an issue that comes up all the time. You have coalitions of every religious group, Muslim, Jews, Sikhs, every group was saying, overrule Hardison, because this is a bad precedent. The court said, no, we're not going to rule it, we're just going to reinterpret it. So this is not like a Hobby Lobby or like Masterpiece Cake Shop case. This is one where I think there's pretty broad consensus, which is why I went 9-0.
Interesting. Okay. Well, let's take some questions from the students for a little while. Yes, sir.
You mentioned dormant commerce clause, and then you joked about California enacting a law. I'd love for you to talk about national pork producers.
I don't want to. I hate that case.
The effects that will have moving forward.
Do you want to do the pork case?
One of the conditions that
I didn't want to
Professor
talk-
Blackman made me
True.
agree to before coming here is he will not talk about the pork.
It's not kosher, but that's not the reason why. I'll say a few words. I am so confused by that case, and I am so confused by the state of modern commerce clause doctrine. I just don't feel I can explain it competently, and that's not a dodge. I mean, I teach common law every semester. I actually skip this topic, right? So the dormant commerce clause is not actually in the Constitution. It's sort of there, right? It says that Congress can regulate interstate commerce, right? That's Gibbons versus Ogden. But what if Congress does not regulate interstate commerce? Do the states have a residual power to do it as well in the absence of federal legislation? And this gives rise to the idea that there's a dormant principle that states can't burden interstate commerce. And now there's at least 2 or 3 different tests to determine whether commerce is being burdened. And I don't even know what those tests are. It's almost incoherent. Maybe Professor Fitzpatrick can enlighten us. I struggle.
I can't enlighten us. I take the position that the dormant commerce clause does not exist.
Nope, it's not real.
And so we ought to overrule the whole thing and to make everyone's life a lot easier, not have to worry about all this stuff. So I'm sorry that we cannot talk
Failure.
in more sophistication about
And
it.
the second I said California, like someone's going to ask me about the pork case. I knew as soon as I said California, I was walking into it. But anyway.
Nick.
I have a similar question.
Oh, no.
Well, going into
Pork.
like Alito, he concurred in Valerie's
Yeah.
case on dormant commerce clause. What do you think explains that difference between someone like Justice Gorsuch and Thomas on dormant commerce clause versus someone like Alito?
Well, I think that Justice Alito is not a very good originalist or textualist for that matter. I think he's a little more results oriented than some of the other ones are. And so I think that explains his support. Probably Robert supports the dormant commerce clause. I mean, the less originalist, textualist justices, I think, are fine with it. I mean, it is very good for business to have this clause. And so I think that's kind of the explanation is they're more pragmatic and they're less pure, I would say, with the principles.
Mm-hmm.
Is that fair, Professor Blackman?
I think that's fair.
Yep.
Hi, I'm Kyle Cornell, so still learning. We've been here for like 5 weeks. But my question was actually about the case out of Alabama regarding redistricting.
Mm-hmm.
And I know now, like that case, I think is actually still sort of percolating its way back potentially to the Supreme Court. My understanding is that in the opinion for that, Justice Kavanaugh sort of like alluded to the notion that he saw like, I guess like this sort of like problem of potentially like wanting to see an end to it you're not like explaining it really well, but essentially something along the lines of like the whole racial gerrymandering thing, and like the courts getting involved, I think their role should be limited. And so my understanding is that the litigants are trying to use that as a way to get back to the court and maybe have him like change his vote. So I was wondering if you had any thoughts on that. Or like,
Yeah,
explain that case.
Sure. So the case called Allen against Milligan, it was a case on the Voting Rights Act of 1965. And this statute has been amended several times over the years. I won't go into all the very specifics, but one of them has to do with when you're drawing maps, how do you handle racial demographics? And the statute says you do not need to have the maps sort of match directly onto the racial demographics. Like, let's say a state is, make it easy numbers, 80% white, 20% black. That's not, 4 districts for white people and 1 district for black people, right? You don't need to have strict mathematics. But there's some precedent saying that if you can draw maps in such a way that you can increase minority representations, they have 2 African-American majority districts, you should do that. And what the court said was that because in Alabama, it was possible to draw the maps with 2 minority districts, and that doing so would not run afoul of these sort of factors. I don't want to talk about complicated. You should do that, right? So the court said Alabama wanted only 1 minority district. It's possible to draw 2. You violate the Voting Rights Act. Okay, so the case went back down to the lower court. Alabama tried it again and said, okay, we're going to draw it such that there's still going to be 1 majority minority district and a second with a higher percentage of black voters. So it wouldn't basically guarantee to have 2 black districts. And they were obviously trying to basically tempt Justice Kavanaugh. This was what the student mentioned a moment ago, right? Kavanaugh said in his concurrence that, the Voting Rights Act is very important, but this sort of can't go on forever. And no one actually challenged that fact here. Like, no one asserted that this entire regime is unconstitutional, so I can't decide it now. And this is what Justice Kavanaugh does all the time, sort of clears his throat and, gives a little bit to the left, gives a little bit to the right, makes everyone happy, right? But the problem is the rubber meets the road. It took like 5 seconds for Alabama to say, yeah, we're going to do that, right? That's what we want to do, right? It wasn't like the ink wasn't even dry. Yeah, Kavanaugh, that, right? And so now Alabama's going back upstairs. As we speak, I think the briefing was completed yesterday, the day before. The court's considering the issue that Kavanaugh raised, that how long can you do this for? I think Alabama's going to lose very easily, maybe 7-2 even, on this issue, because you don't want to raise this on an emergency posture, right? Right after the court just said, Alabama, you can't go with 1 district, they tried doing 1 district, right? So they're not ignoring the court. They're trying to sort of figure out the gray area, if I can say that. But there'll be some case that's properly presented where this issue might arise. And why this matters, though, is that for the redistricting coming up in the 2024 midterms, you're going to have, I think, in Alabama, Georgia, maybe one other state, additional Democratic districts created. So this could actually flip the House.
We actually have a suit that was just filed in Tennessee.
Oh, Tennessee too?
Challenging our past redistricting after the Alabama case came down. And I just want to say, I don't know this statute intimately, but I have never understood how any of this is constitutional.
Nope.
Looking at race, this obsession with race, this fascination with race, whether either to suppress black voting power or to increase black voting power, it seems very contrary to what we normally say about the Equal Protection Clause, which is you're not supposed to be considering race. And so I just wonder if at some point this whole thing is going to be tossed out. What's that?
The 15th Amendment to the U.S. Constitution gives Congress the authority to remedy these issues. It's very clear.
Okay, thank you. Thank you, Grayson. Any other, yes, sir.
Oh, yeah. I had a question about the Students for Fair Admission case. So in the wake of that case, colleges and universities have been encouraging their applicants to expound more greatly on their experience as a member of a certain racial group. And so I'm just wondering whether there's a genuine concern that if universities rely on that information to make their decisions, but that actually vitiates or circumvents the dictates of this recent rule.
Brian, you want to do this one?
Well, yeah, I mean, so I think a line that the Chief Justice put in, that says you can write an essay that talks about how race has inspired you to do things. This line is going to really allow the universities to evade the ruling. It's going to be very hard to prove that universities are discriminating on the basis of race when everyone is telling stories in their essays about how race has affected their character and their lives. It's going to be very hard to prove now that the universities are discriminating on the basis of race when they use that information. It's going to require all kinds of discovery, all kinds of expert analysis. And so I think that was a gift to the universities. And so I don't expect a whole lot to change after this decision.
Yeah. What will change is Adam Ortaro will get a lot of attorney's fees. Another national resident. I mean, look, the litigation is
But
going to be
it'll take
ugly.
another 20 years.
And there'll be discovery. There'll be a lot of discovery
get
to
all
embarrass.
this thing resolved by the Supreme
Yeah.
Court again. It's just, it was a real mistake, I thought, to put that in.
But he wouldn't have had Kavanaugh's vote otherwise. He
Really?
needed. I think Roberts and Kavanaugh needed to hold. I don't think Brett would have the stomach for that.
It's a big loophole. And-
It's a
and the
giant.
universities will use it. So I don't think a lot's going to change. Everyone's predicting massive drops
No.
in the numbers of blacks and Latinos in the universities next year in the entering class. I don't think we're going to see it. I think we're going to have very consistent numbers.
Talked about some of various opinions.
Yeah.
What about her non-opinions? Maybe the kind of tip for tat on the Fifth Circuit, if you can talk.
Have you
about
read my blog posts?
vaguely,
Vaguely.
how the stays and injunction process works?
Okay, so the shadow docket. You know, this thing that doesn't. It's like the dormant
We're
common
going
clause.
to read this book in my Fed Courts class.
I'm sorry.
Professor Vladek's book, The
Oh.
Shadow Docket.
Oh, it's a.
I have to present both sides.
You do. You
Professor
do.
Vladek.
So, I mean, the idea of the shadow docket is not controversial. The court has an emergency docket in which they have sometimes resolve cases in a very expeditious fashion. The rule on the emergency docket is you need 5 votes to do anything, right? If a lower court screws up, you need 5 votes to stay it. If the lower court didn't grant an injunction, you need 5 votes to grant an injunction. Justice Barrett and Kavanaugh, to a lesser extent, have signaled that they are not going to allow lower courts to grant emergency relief. Now, in almost every single case, it's the Fifth Circuit, where I live, granting emergency relief, and the Supreme Court reversing them. In almost every case, Justice Barrett's on the other side. So I think what we're seeing is the sort of the court's conservatives are to the left of where the Fifth Circuit is. So I always say the Supreme Court is not the Fifth Circuit. Had Trump picked any of the Texas judges, we have a very different country. Any of them, any one of them. Willett, Ho, Oldham, we have a very different republic right now.
Interesting. Well, I think we have to end on that note, don't we, Dalton?
Time's up.
Thank you
Thank you
very
so
much.
much.
A lot of fun. I had to finally button my jacket. I was looking at myself and I